Welcome to National Tax Research Foundation. The purpose of this video to give some clarification given by the Advanced Ruling Authority as well as the Appellate Advanced Ruling Authority also. In both situations, both the authorities given the finding against the applicant. The contention of the applicant is he has rented his residential property to some other purpose, for sublease purpose or to conduct some hostel, some business activity. But as far as the applicant is concerned, his property is equal to residential property. But advanced ruling authority has taken a different stand that is also upheld by the appellate authority. The contents of the appellate authority will be explained by our learned speaker C.S. Suprasad Garu. Over to Suprasad.
Yes, sir. Namaste. Welcome to all. This is a very interesting case by Advanced Ruling Authority Karnataka, and this is a case of Ambrish, Mr. Ambrish T. Vasudeva Ambrish. It had got multiple issues involved in the case. Let us disentangle one by one. First one is, in this case, what had happened is there is a group of individuals, 4 individuals. And all of these 4 individuals have jointly letted out their property to one company, and that company is running an hostel. The appellant's contention is that finally the hostel is a residential dwelling, residential accommodation, which is exempt under GST by notification 12 of CGST or 9 of IGST. So because it is an accommodation, residential accommodation, it is exempt from tax is a contention of the applicant. Now, the cases, the issues that we have to discuss are: one, in deciding whether it is the residential accommodation is exempt or not, shall we see the ultimate use of the property or the service between the service provider and the recipient alone? So ultimately, whether it is used for residence or not, whether we have to consider that, or shall we have to decide the case based upon the nature of the transaction at every step? In the present case, the applicant, that is Vasudeva Ambrish, is not giving directly to for the residence purpose, but he is giving to a company which is running a hostel. Now the second leg is, okay, for a while let us assume that we will consider the ultimate use. Whether the hostel accommodation can be considered as a residential dwelling or in the nature of a temporary stay in the case of hotel, motel, guest house, campsite, boat stay, etc. So whether a hostel stay can be considered as a temporary one or a permanent one in the nature of residence. That is the second point that we have to decide. Okay. And incidentally, certain other issues are also involved. Can the application be entertained by one of the individuals who is involved in the supply? Whether the supply is made by one of the individuals or whether the group is a service provider, whether the group as an association of persons or a body of individuals, whether it has to be considered that the group of individuals is a service provider, but not any individual person as a service provider. This is very, very important to understand all the co-owned properties, because the co-owned properties is a very common phenomenon. So it is very interesting case because of all these things. Let us take up issue by issue. First thing is, this case had went for Advanced Ruling Authority Karnataka, and the Advanced Ruling Authority Karnataka had held that exemption is not available. So aggrieved by that, the appellant had preferred a case to the Appellate Authority for Advanced Ruling AAAR. So one of the important observations made by the Advanced Ruling Authority is that the group of individuals is a distinct entity from all the singular individuals. This is very, very important. Though not the core of the case, it may not come in the highlights of the case law, but this is very, very important point under discussion. So the group of individuals shall be considered as a different entity from all the individuals. So the service provider is a group as such. So the turnover of the group shall be taken. We have seen whether in case of common or a co-owned property, the threshold shall be calculated individually or at a group. The CPIC circular had given a different thing, but in this case, the Advanced Ruling Authority is saying that the group is a service provider, but not any single individual. But still, it had entertained the advanced ruling. That is another important point. it had entertained the application and then pronounced its ruling. So the important first key takeaway is it is not any single individual in case of a co-owned property. The service provider is the group as such, whether it is a partnership or a joint venture or an association or a body of individuals is a different story. Now let us come to the second point. Whether hostel accommodation can be considered as a residential dwelling or a temporary stay. The applicant had contended lot of Supreme Court cases. The applicant had already had put before the authority the definition of residential stay as given by the CBSE educational guide and etc. Normally, when there is a considerable permanency, when there is a considerable period of stay, and it is not a temporary like 1 or 2 days of a stay in case of a hotel where the day-wise billing is per day, then we have to consider it as temporary. But when there is a considerable stay for a considerable period of permanency, then it has to be considered as a residential dwelling. But surprisingly, the appellate advance ruling authority had pronounced that staying in a hotel is only temporary. Staying in a hostel is only, sorry, not a hotel. Staying in the hostel is only temporary. In our limited personal opinion, and also in the opinion of NTRF, hostel should be considered as a semi-permanent or a permanent stay, because students lost a lot of workers, working women, working ladies, their residence is nothing but their hostel. Okay, so we cannot disregard hostel as a residence. Okay, anyway, that is one part of the story. In this case, the AAR had pronounced that staying in a hotel is only temporary, and we cannot consider the staying in a hostel cannot be considered as residential accommodation. That is one surprising fact. Be that it may, the third leg which we have to discuss is what is the nature of supply between the owner of the property versus the hostel, the provider of the hostel. Okay, between the owner of the property and the recipient, in this case a company, D12 space, etc. The company is taking the property on rent and it is running an hostel. It is running its own business venture. So between the lessor and the lessee, there is no question of residence. Maybe there is a concept of residence. Between the hostel and the resident of the hostel. Okay, so therefore the entry talks about when the property is let out for the purpose of residence, which means that one who is taking the property, the recipient, in the immediate recipient, shall use it for residence. So this is very, very important finding and a dangerous finding. Now what happens if I take my land, my residence, and I sublet it? If I sublet it, then what happens is I am in the business. If I am in the business, between the first person and me, it is taxable in view of this advance ruling. So this is a very, very important advance ruling, very elaborate one also. Certain important points were discussed upon, certain procedural aspects were also discussed in this case where the ruling was not pronounced within the 90 days and all. But anyway, the core of this advance ruling is based on these three pillars which we have discussed. Thank you, sir.
So in the opinion of NTRF also, it is a taxable event. There is a taxable event.
Yes, sir. It is a taxable event because of the fact that the immediate recipient is not using for residence. He is using for his business.
Maybe okay. My property is a residential property. On that particular date till I enter in the agreement, I am using it as residential property, and my purpose of using as a residential property. But some other person using differently. After entering in the agreement, it is his discretion. Whether am I liable to pay GST on this transaction?
Exactly, sir. We have to pay because the wordings of the entry number 13, if I am not wrong, is that service of renting of residential accommodation for use of residence. So there is a double lock. What we must give is a residential accommodation, and it must be put to use for residence. That is also there. So it is not only the nature of the property that I am giving, but it is also the objective or the actual use it was put through. That was also checked in the entry. So therefore, there is a twin test to be satisfied. So to that extent, the finding of ruling is perfect, and it says that the immediate recipient is not using for residence. Maybe the ultimate resident, to him it may be residence. That is a different story.
So hostel accommodation is not equal to a permanent residence.
To that
That is the
extent,
function of
yeah, to that extent, it is truly debatable, sir. Now, what happens? I constructed a property and I am running an hostel on my own. So it is my own property. I'm running it for a hostel. Then, am I eligible it as an renting out of residential accommodation? That is one thing. Of course, there is another alternate exemption available in the GST Act, where the hotel, in guest house, campsite, if they are charging a consideration less than 1,000 rupees, that is also exempt. So maybe if not under this entry, they may be getting an exemption under that entry. That is a different story. Okay, but if you take the case of a Mumbai, maybe the hostel itself may be costing more than 30,000 a month, possible. So if that be the case, can we consider or can we not consider hostel as a residence?
Okay.
Hostel is a residence because there is definitely a reasonable amount of permanency of stay. The billing is not per day, rather it is per month. The intention of the parties is that they stay, that even they collect deposits of 2 months or 3 months of advance. In case of a hotel, there is no concept of giving advance for a month or a two. Okay, so we have to consider the whole framework, and to the extent the ruling had held that hostel is not residential accommodation, we have a issue with that.
Okay, sir. Dear viewers, in future we will have a more interpretation on this particular subject because a lot of litigation is going on in future also. Please wait for some other advanced ruling authority from some other states. So please stay tuned for more updates from India. Thank you.
Thank you.